The Larimer Small Business Development Center is a partnership of the U.S. Small Business Administration, Colorado SBDC, and Front Range Community College. In locations throughout Larimer County, we offer free confidential consulting, educational business training, and connections.
So just in case you're not familiar with the SBDC, we are here to empower Colorado businesses to thrive. We provide high quality training, free confidential consulting, and connection to resources. And we're super proud to be partnered with the USSBA. We are hosted here locally at Front Range Community College, and we are part of the SBDC network. I'm super excited to introduce Brian Hanning, who will be leading this webinar, and then myself and a colleague will be keeping our eyes on the chat. If we get a lot of questions in there that Brian hasn't covered, we'll be sure to bring it to his attention. However, I'm sure you're going to learn a lot from what he has to share. Brian, I'm going to hand it over to you, and thanks so much for doing this, and everyone, thanks for being here.
Absolutely. All right, I'm going to spotlight myself, hopefully. And then, yes, okay. So first things first, hi, my name is Brian Hanning. I run Hanning Law Limited here in Fort Collins. So I help small businesses with all of their legal needs, from getting started with their company through to reporting issues like the Transparency Act, as well as other pieces like copyright and trademark. I've volunteered with the with Hope and the SBDC for a number of years. So if you ask for your list of attorneys, I may be on it. And today we're going to talk about the Corporate Transparency Act. This was passed in 2020 and went into effect this year. And it's really a new piece to cover some specific questions and issues. Now, the main purpose of the Corporate Transparency Act is to create a registration bank, a database for ownership of more companies that exist. The estimate I saw was that this covers 30 to 32 million different companies. And most likely it will include yours, and we'll touch on that momentarily. And access to this database is to be limited to the financial crimes enforcement arms. So police and FBI and other law enforcement agencies looking to see who's doing financial crimes or crimes where we need to have a shell company to move them around. So in the act itself, it talks about human trafficking, drug crimes, those kinds of things. So yeah, this is really targeted at that. We're all just caught up in the middle of it. Now, with that, all of this information and your registrations are going to be here at fincen.gov/BOI. This is the hub of it. You can get the law if you want it. Otherwise, just to the right of the main screen, you will see a file here. And you can either file online or download a PDF. That PDF is the same thing. You fill it out, upload it. It really takes about 10 to 15 minutes for simple companies. And we'll talk about where some of those complexities can arise. Of course, the first question everybody's going to have is when? Tied very much with do I? But at least the when question is something that's easy to answer, which is If you've created an entity before January 2024, you have the rest of this year to file. My recommendation that I've been making is try to get it sometime between now and November, just because if there's a big rush of people in November and December, you may have server issues. There is an act in the House right now, or that just passed the House, that would extend this for another year. I would not rely on that. I would file before that because we're not necessarily sure what kind of process that's going to be. For anyone who's looking at starting a company today, you would have 90 days to fill out your report. And we'll cover what's in the report here shortly. And then starting next year, it's going to be 30 days. A lot of times when I talk to people about this, the question that I get is, well, is this an annual reporting piece? And the answer is, unfortunately not. That would mean we could put it on our calendar and do it every year at the same time. It is instead, after you filed your initial report, you have an ongoing duty to provide any updates or corrections 30 days after you notice the need for an update or correction. So, for example, if you start a company and you start that today, you have 90 days to file your initial report. You get it filed, everything's good, and you notice you spelled your last name wrong because you were in a hurry. You have 30 days from noticing that to provide that correction. Okay, we've updated it, all the names are correct, but our lease is up and we're moving office spaces from Unit 101 to Unit 103. We have 30 days on that move to notice that address change. This will also include updates to whether you're exempt or not. And there's some complexity there, and we'll get into those exemptions shortly. This is the kind of fear-mongery piece of this, in the sense of we know what penalties exist for failing to file. What we don't know is how much they're going to lean into this is a brand new thing and we're giving a little bit more space in 2024. We don't know if they're going to go right for the maximum penalty immediately. We don't even really know how funded the enforcement arm of this is, or whether it has to be discovered and then referred. There's a lot of unknown here. But the maximum penalty for willfully failing to comply is a $10,000 fine with up to 2 years of imprisonment. So this would qualify as a felony. And, since it is a relatively short filing and a free filing, it may be better to let somebody else find out how vigorous the enforcement is. With that, who has to report? Well, in the reporting requirements, we have 4 categories of things that will be reported on. So you have your reporting entity. So this is the company that qualifies to submit this information. You have the beneficial owner or the individual/owner who exercises substantial control. So the example with that is going to be Mark Zuckerberg. So Facebook/Meta has done so many rounds of financing that he really only controls a small percentage of the total equity, but that total equity all goes through him and he basically deals with that. There's some more tests and we'll talk about that shortly, but roughly that's the piece. The beneficial owner is just literally an owner of the company. And again, there's a test. We'll talk about that. The company applicant is going to apply for companies started after January 2024. So for everyone else, it's not an issue. But for 2024 and forward, when you start the company applicant is the person taking the steps to make sure that the reporting entity exists. So we'll talk about that more here in a minute. And of course, there's what is a reporting entity? Well, it's really going to be looking at that second bullet on this slide. It's an entity created by a filing with the Secretary of State. I've been asked a couple of times, what does that mean for a sole proprietorship? And where that's most likely going to come down is whether or not some of these secondary filings that happen with the Secretary of State count as, quote, created by. So let's talk about an LLC, for example, which is when you create an LLC, you go into the Secretary of State, you go to their business website, and you go, hey, I want to file my articles of organization. You fill out the form, you submit it, and with that, you have created an entity. That entity is therefore a reporting entity unless it's exempt. So anyone who has an LLC, a corporation, a co-op, a limited partnership, you're going to need to file. That sole prop or a general partnership that doesn't really need a filing to exist probably doesn't need to file because they weren't created in that sense. It is possible we're going to get a piece covering that, but right now we're really looking at the created by and basing it off of that. Not exempt under the Act. That is going to be our next subject, but first, it is the reporting entity that files. So not you or you and your family or you and your partner who are the owners of the entity. It's the entity itself. I'll talk about this at the end as well, but generally speaking, it makes a little bit more headache, but not too much. And for most people who have a one-person company, you're just going to file it yourself. There are 23 exemptions. Most of these, if they're not duplicative, are very highly related. So for example, there are several exemptions around banks and credit unions. So if you're a bank, a credit union, or other financial institution like a bank or credit union, you don't have to file. Same if you register or file under any of the Securities Acts, the Exchange Acts, the Commodities Acts. If you're lucky enough to be a utility company organized under a governmental entity, probably that. The piece there that will probably need more exploration is if you are regulated under the PUC, the public utility companies, but are more like a taxi company or a tour company. Those are definitely falling into you may want to register just to cover your butt. And then insurance and registered accounting firms. In essence, these entities and these groups of exemptions are all covering entities that already have financial ownership reporting requirements. Meaning, if you're filing because you have a Reg D securities filing, you're already providing the information needed in this. Now, as we go forward, there are a couple of more exemptions that are going to be more apt for most of us. So the first one is going to be the tax exempt entity. So this would be any Colorado nonprofit that is looking to file as a 501c, or specifically the 501c3s. When you are a 501c3, you are exempt under this act. So you wouldn't have to do updates or disclose ownership. But you have to keep that registered until you are exempt. So it can take 6 months, last I heard, and that could be off by 3 months in any direction. But if you're registering for a 501c3, that means you're probably outside of the 30 to 90 day window, 90 for 2024, 30 for the future, and would therefore need to file that you're not exempt until you are. Your next big one is the inactive entities. So these are entities that have not been engaged in active business for a while. So I know many entrepreneurs who have 3 companies that they've worked through. One of them they started in 2012 and it died in 2014. That company doesn't need to be registered. It is only businesses that are currently operating or currently doing business that need to be registered. I skipped through the 6 factors because really, if you have an inactive entity, you're going to know. And if you don't, you'll need to file. The other one that's going to come up for a number of people is the large operating company exemption. So this is your mid-sized or large small business exemption and up. So it's 20 full-time employees. So most restaurants will have that element. A physical office or physical store. The specific language is office, but I'm pretty sure they're interpreting that largely so that it's retail spaces included. And then it's if you have filed your income tax showing at least $5 million for the last year. So if you end the year with 19 employees and $4 million, you would still need to file. So this one is going to be one where you may want to be cautious around the edge, but once you get a certain level of consistent revenue and consistent success with it, you're going to be exempt and not have to worry too much.
Brian, there's a couple questions. Do you want me to go ahead and tell you what those are now?
Absolutely.
Okay, so one is if a company is not conducting business, but is filing 0 tax returns, is that considered active?
It's going to depend on how recent it is. I'm going to say that if you're not actually conducting business, you're going to be more likely to fall into the not active. But if you're filing tax returns on it, that might be enough activity to file. I'd be happy to talk with this person more through the six factors because there is going to be some, it depends on that.
Okay, great. Will you I can't remember, at the end of this, do you provide contact information for people?
Yes.
And there was one other, I actually had this question too. Do you have to meet all three of these criteria or just one in regards to the large operating company exemption? All three?
It's an and. So
Okay,
you have to do all three.
okay, great. That's all the questions right now.
Where this is going to be, where the large operating company exemption is going to get interesting is the Corporate Transparency Act. I shortened it to, you've created it with the Secretary of State, but it's a little bit broader than that. It's wherever you can create it officially by filing. So that would be with your tribe or in your comparable thing to the Secretary of State in Ontario, Canada, and you're operating in the US. So that physical office within the US could get interesting for, say, Sony, that definitely qualifies on at least two, but whether or not Sony Korea operates in the US versus Sony of America. But that's their problem. It's just a fun thing for me to think about because I'm that kind of interesting person. Now, we talked about this at the beginning, which is there's the four groups of people for your company. You have your entity itself, you have the company applicant, and then you have the ownership questions. As I mentioned, if you are somebody who filed the document to create the reporting company before 2024, you are not included in this. It's only once the Corporate Transparency Act took over and started. So going forward, anyone who files the document is a company applicant and would need to be reported. We're looking at some different things in the Corporate Transparency Act that will impact this. But at least for the time being, you may be asked to file your own by attorneys, accountants, registered agents. There is a FinCEN number where you can be identified by a 12-digit number. We're still trying to figure out how that works fully. They've said it exists, that you can get it, and we're just not sure all of the details with it. But once that happens, it will probably go back to how it was in 2023 with starting a company where your third-party company will help with this. But for now, it's the person who directly files the document. When we turn to the beneficial owner, like we've talked about, there's the two specific categories. We have the ownership interests, and we have the people who are controlling the direction of the company. With the ownership interests, the definition is broad enough to cover co-op interest, LLC membership interest, shares. And the question is whether or not you have at least 25% ownership. So with that, who would need to file? Well, let's say there's 5 owners and each of you own 20%. There would be no reporting as a beneficial owner. We would still have to go through the control question, and there might be filing there, but at least under the ownership element and ownership test, nobody would file. If we had 4 people, somebody had bought out their friend, we would have somebody with 40% interest. Blue would be the only person reporting as a beneficial owner. And if we had 4 where everybody has 25, all 4 owners would file or have their information submitted. Now, this is a direct or indirect element. So, for example, we have a more complicated business structure here. So, how do we deal with this? Well, 50% is owned by Jane. Jane just owns it. She owns more than 25%. We're done. Our analysis is complete. We're registering and reporting Jane as an owner. Green is a third-party company, and we have to look into who owns that company to decide how this is going to be filed as. So this could be a filing of it's just the LLC, or we could have an individual named. So it is a piercing of not just your ownership, but of anybody who owns you. And then let's say this last 25% is owned by a trust. Well, there's no quote unquote owner of the trust. We would have to look at the substantial control factors to determine what would be going on in this situation. But looking at this Travis, so like we said, Jane's the beneficial owner. We know that 50%, we're good. But we would need to do more of the tests for the other 2. It's the same entity. We're really just looking at Travis LLC right now. So if Travis owns Travis LLC 100%, we then know indirectly that Travis is a 25% owner in this underlying company, in Muse. Therefore, when Muse files its reporting, it doesn't necessarily say Travis LLC, it would say Travis is a beneficial owner. Where when we give an example like this, where Travis LLC owns the same 25%, but it's now broken up through 3 different people, none of those 3, as we see in that math over to the left, are 25% owners. So we would just indicate that it's owned by a company, and Muse LLC would file for that. Travis LLC would have its own filings. We're not touching that at the moment, but we wouldn't have an additional beneficial owner for Muse LLC. Like I said, ownership is both very easy and very complicated. It's going to depend on what your structure is. For most people, we're just going to be looking at, does Jane, Joe, and James own at least 25%? If yes, then what do we do? We file the ownership information on them. But if you have employee vesting, if you have convertible notes, if you have share structures where one type of share has bonus voting percentages or bonus profit interests or phantom stock, it's really going to be a time where you're going to want to talk with somebody about, does this translate from what it could be into a present day 25%? And keeping with that, all of those things are going to be assumed to happen today. So if I run Hannon Law and I have my partner attorney and I give that partner attorney a vesting option of 25%, it's not going to matter whether in the contract this person qualifies under that vesting. We're going to assume that they do and give them as a beneficial owner. So like I said, if you have a more complicated ownership structure, please reach out to me or another business attorney and we'll help you through this. The last group of people that may get reporting is your exercises substantial control. This is going to be another area where there's going to be clarification sought because some of this is kind of vague. So, for example, there are three main areas. One is the senior officer. The senior officer is the person who's got the day-to-day operations of the company at a high level. So they're determining structure and determining whether or not financial expenditures are going to happen. So frequently your senior officer is going to be the name in the statute, which is on the left of this. So if you're an LLC, if you have a manager is going to be your senior officer. Your treasurer for a corporation is. But as we know, we can name things whatever we want. So if we have a CEO, that may qualify as a senior officer, depending on what that person's roles are. So it's going to be in part that level of responsibility and control. The next piece is if somebody has the ability to appoint or remove senior officers or a majority of directors. Again, this is going to depend on what your entity structure is and what deals you have. If you signed an agreement with your dad to get you off the ground, and part of that agreement meant that your dad got to confirm senior officers, it's likely that dad now has the ability to appoint or remove and would have substantial control. Again, it's really going to depend on some of these ancillary and secondary agreements. And then we have your important decision maker, which again is a very big piece that we're going to want some more clarification on, in part because it just is going to be, well, we have authorized this person to do it, but they don't necessarily have infinite control over it. Again, we have an idea, we have the general shape, but some of the details still need to come into focus. But your important decision maker, are we starting a new line of business? Are we changing location? Are we focusing in Larimer or are we focusing in Weld? In Larimer, are we in Fort Collins or Loveland? Who's signing your big contracts? Who's determining whether we're assuming debt? That person is going to be deemed to have substantial influence. If it is one person. If it's multiple, if it's by committee, we're talking about it as a singular thing, but if 2 or 3 people can do it together, we're probably going to want to register the 2 or 3 people. But again, that'll start to depend on your structure and your elements within the business. An important thing for all of this is we're talking about this directly because it's simpler, right? does Brian have the right to remove Janet from being the CEO? Yes or no? Yes, therefore he has the right to do this and has substantial control. But if Janet, by any other contract or by the loan, has protection of it or has the right to remove Brian, that may be an indirect thing where they don't necessarily have it through the company directly, but still has that right and could qualify. Hope, I think there's a new question. Happy to answer that if you'd like.
Yes. I have two S corps. I have 100% an interest in both of the S corps. Both are actively doing business. I also have one LLC used to hold real estate. It does not have any bank accounts or deal with any money. I have another LLC that hasn't been used in many years. Which ones have to report?
Probably the first three. So an S corp is a tax collection layered over a state entity. So it's either a corporation or an LLC through the Colorado Secretary of State. If they're operating, then they would register. So we said that for the first three. The fourth one was one that had been languishing for several years. That one will probably fall as an inactive corporation or an active entity and therefore wouldn't be registered. If there's more complications to that, or if there's some other deals that might change, but from the question and how the question's asked, that would be what I would say. But yeah, indirect. So if you're in any kind of financing arrangement or other contract that might impact, we would want to dig into that to see if they have enough authority to count as having substantial control and therefore report. So I've referred to the report and the filing and all of that several times, and I'm sure you're going, Brian, why didn't you lead with this information first? And the answer is because you wouldn't have stayed through the rest. I mean, because all the other pieces are interesting for me. So for your entity, the entity has to report who and where the entity is. So that's your name of the company. So when you've registered this with the Secretary of State, I'm Hanning Law Limited. Reporting company legal name, Hanning Law Limited. If you have alternative names, for example, my website is thatdamnlawyer.com. If I've filed that with the Secretary of State as a trade name, I would file That Damn Lawyer as an alternate name. We would do any tax identification information. So if you have an EIN, that would be here. If you're not sure what your tax identification type or number is, consult with an accountant and make sure you have that laid out. This is probably where you would indicate that it is an S corp. I just forget off the top of my head. The jurisdiction is going to be Colorado for most of us, but if you're not for Colorado, it's your tribal jurisdiction. It's your tribal jurisdiction in Canada or other First Nation. Where you filed in what province in France or Hampshire in England, those kinds of things. I don't think they're Hampshires. Anyway, wherever you filed, that's where we have to say that. And then your current US address. Most of this information should be on your Secretary of State filing, and then your tax information. For all of the individuals, so this is your company applicant, your beneficial owner, and anyone who qualifies as having substantial control, you're going to file this information about them. So that is name, date of birth, address. And to confirm that, you're going to include your identifying document. So this is your driver's license, your passport. And so you will need to scan that in and attach it to your filing. So for anyone who's a one-person entity, it really is pretty simple. You grab the information about yourself, you grab the information about your company, and you file it. Like I said, 10 minutes. It's really when you start going, okay, do I need to find out who has substantial control because we're 80% owned by my family trust? Those are the times where it's going to be more complicated. Be careful. There are people scamming, issuing scams about filing this. You've probably seen a variant of it with your entity registration anyway. You'll see these these junk mail flyers that are pay us X amount of dollars to keep your Secretary of State up to date for this year. You're going to be seeing those with this kind of information as well. So be careful. I would recommend that unless you have a complicated situation, to just file it yourself. In part because many business lawyers and many accountants aren't really set up to hold your passport images. It's privacy information, and some of them just don't have that ability or desire to have that ability.
Brian, there's another question.
Yes.
Okay. If when I incorporate, can I use my mailing address is a private mailbox? Can I use that, or do I have to use my home address if I don't have an office?
So there are a couple of answers on that question, which is one, Colorado Secretary of State needs a mailing address, and I believe they've taken steps to prohibit your primary office address from being a P.O. box. So you would need a physical address and then a mailing address. That got updated last year, and I haven't dug into it recently. But that's a relatively new policy there.
Oh.
So that would answer it for your business, which is you would need to file your addresses that are basically on your Secretary of State filing.
So they said, okay, they commented, good to know. And then there was another kind of comment slash question. It sounds like it's better to report a BO if you're in doubt. Is there any downside to reporting someone as a BO?
Not really. So this is yes and no. So the database this goes into is supposed to only be accessible by investigators of financial crime. So for example, the relevant department of the Colorado Financial Crimes Investigative Unit can access it. It is a database with everybody's identifying information and date of birth. We would be foolish to assume that this isn't going to be at least attempt to hack. So that's your downside, is you have personal information on there. And if you don't need it exposed in another database, then you may want to avoid that. And Target knows everything about you.
Okay, there's another. I'm sorry, Brian.
You're fine.
Let's see. Do all beneficial owners, senior officers, and important decision makers need to file, or is it sufficient if only the beneficial owners file?
All. So this information that's on screen, we would do for any beneficial owner, any person who exercises substantial control, and any company applicant, to the extent that A, they qualify, and B, they are involved in the business. So all of those pieces that I've talked about earlier of, is it a senior officer, then we would file them. There are certain exemptions that we haven't specifically talked about. For example, an employee who's just an employee who also has these authorities may not need to file. What that limit is we're going to have to find out. But yes, if you started a company today and you, Hope, were the 100% owner and Brian, was the senior officer, we would have to file, whoever filed the business, the company applicant, whether that's Hope, me, or a third company party, Hope as the owner and me as exercising substantial control.
Okay, there's another comment, but it's the entity that files, not the individual BOs, correct?
Yes. Which wonderfully transitions me. So thank you for that question. Thank you for all of the questions. That one in particular, because you helped transition. So yeah, the entity is the one who's filing. The legal basis of creating an entity is that we have a split between the entity and the owners, so that there isn't, liability of, oh, somebody got in a car accident and now the entity is having to pay for it, or the entity had a product injury and now the beneficial owners have to pay for it. No, we have that split. So for people who aren't just, so I would recommend this for everyone, but specifically for companies with more than one unrelated owner, you're going to need to do some kind of authorization and some kind of agreement to allow for the sharing of this information. Like we talked about, it's personal information and we have to authorize it. I have in this example 3 owners. All 3 owners aren't filing, the entity is. So we have to appoint someone to file it and give that person the right to collect everyone else's relevant information. So I would highly recommend, like when you, with your taxes, in your operating agreement for your LLC, you've probably said, we appoint the main member to file our taxes and to hire any counsel that they need in order to do that. You'll probably want to do something similar for this. You're also going to want to require notice of changes. So for example, if somebody gets married and their name changes, we need to know that, and perhaps we know it, but the entity doesn't necessarily. So we would need to provide that. Doing required disclosures. So if you have a complicated ownership piece, like we talked about earlier, where 50% of the company is owned by your family trust, we would need, or we would want, ideally, in this operating agreement or other shareholder agreement, etc., that the trust and the relevant named people in the trust give us the disclosures. We may even be asking for disclosure of trust documents so that we can do appropriate analysis on substantial control. So yeah, right before this, Hope and I were talking, and I went, it would have been nice if they had talked to, attorneys or people involved with small businesses to have some of these discussions before this went live. But we're really going to be figuring out some of this because the entity is the one reporting, and legally, the entity is a different person and therefore does not know your date of birth. It's a thing. Now, you're also going to want to cover some things depending on your goals. So, warranties of accuracy, if you're going to work with an attorney to file, because we've gotten confirmation that you can do that. Well, you got to have permission to share that, and there has to be mutual agreements. Privacy, again, you're giving me your date of birth and potentially your passport. Identities have been stolen with less. So we would want privacies and relevant steps for that. With that, I've been talking for about 50 minutes. I'm sure you all have other questions, and I am happy to answer them. And here's my contact information. You can email me at brian@thatdamnlawyer.com. I also have a contact form on my website if that's easier. And again, my website is thatdamnlawyer.com.
Ryan, I still laugh after knowing you all these years and your name and how people can find you.
I try to have some personality.
Okay, let's see. I think, okay, there's a thank you. Okay, there's a question. Maybe some, wait. I'm sorry, my chat jumped.
That's fine.
Someone's asking about the URL required for reporting again. So I know
Yep.
that's the finson.gov/BOI, I believe.
Yes.
And then another question, will the presentation be sent out to attendees? So Brian, I know you're probably like, what in the world? We typically do send them out if it's okay with you.
Please. It's a lot of information, and it is complicated enough that I could probably talk for about 4 hours. I'm sure you all will have questions tomorrow.
And for people that have a simple company, I can say firsthand, as you mentioned, it really doesn't take long. And what took me the longest is I didn't realize I was going to have to upload an image of my passport. So I had to jump away from the FinCEN site and grab it and copy it. But honestly, it really was like a 15-minute exercise. But I think there are some people on the line that have more complicated structures, maybe more history. So thank you for all those details.
Yeah, and I'll re-second that, which is if you are a one-person company or it's you and your spouse, just get on there and file whenever you have 20 minutes. Like I said, the application, you can download it. So, download it as a PDF, print it out, take a little while to make sure you have everything without stressing about it. Upload it. It's not really a big deal. Once you have unrelated people, that's when it starts to become a piece of, okay, John owns how much? 75%? Okay, so it's definitely John. But is Dave, who owns 25%, that? Okay, well, Dave, you've got to share this with John. Well, oh goodness, now this is a mess. So it's really once you start getting into that situation where you're gonna want to talk with somebody.
That may be it for the questions in the chat. So Brian, I just want to thank you again so much for your time and walking through this, being so calm and patient for this thing that everybody was really very concerned about.
Thank you for participating in this online learning opportunity from the Larimer Small Business Development Center. Before you leave, why don't you schedule a free consulting session with one of our professional business consultants? You can request your appointment right from our website. While you're on the website, be sure to check out all of our upcoming programs, events, and workshops that we'll be offering in the near future. To stay up to date with all that's happening at the Larimer SBDC, we invite you to join our email list and to follow us on your favorite social media platforms. Remember that we are here to help you start, build, and grow a successful business.